Welcome to Third Fridays, the monthly legal talk show from LOIS LLC featuring attorney Christian Sison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Sison.
Hi, everybody, and welcome to a new edition of the Third Fridays podcast. Got a little doozy for you guys because it's going to be the first podcast episode ever where I've invited a claimant's attorney to talk to me. And maybe it's because most of them hate me, but my guests today, I think would say otherwise. I'd first like to welcome back my partner Noah Pollack to the show. I think you had an episode where we went into detail about the medical treatment guidelines and nerded out for 30 to 40 minutes.
I remember that fondly. Yeah. Think about it from time to time.
Welcome back. And our first ever claimant's attorney guest, Sarah Baia, welcome to the show.
Hi, thank you.
So we have this this case here that came down from the third department last month, and it was, I take a very keen interest in seeing where the Appellate Division overturns the Workers' Compensation Board, and I know over your firm's social media, you guys have been promoting it, in due course because of what had occurred, and I think this would be a good one to really touch on, given that Noah's a big construction expert at our firm, and also Sarah, since you were basically lead counsel for your firm on this one, right?
Yes, I didn't do the litigation. I do the appellate work in our office, so it's interesting to pick up the pieces and see what happened, because once the record's set, it's set.
Right. So when you, if doing the appellate work, right, we have a claimant who, was like a safety manager or a safety inspector. He alleged that he was pulling a gate in a parking area that resulted in an injury to his left bicep muscle and a torn rotator cuff in the left shoulder. He goes and gets shoulder surgery, 1 week after this accident. And the claim is controverted by the carrier. You go through the regular course of events with a trial. And, Sarah, you mentioned, just taking it over from the trial attorney. The case is disallowed. What did you think about your office's chances of getting that overturned?
I thought it was such a strange case to begin with. The gentleman who we represent, Mr. Espinoza, did work for an outside company. So it was almost like a general special issue. It was an issue with direction. The judge disallowed the claim, and then the board panel disallowed the claim. This came on my radar after we lost, and I was so surprised. I did not write the brief to the board, but I took it over when it went up to the third department. We filed the notice of appeal, and I wrote the application for full board review. So what happened was at the trial level, Mr. Espinoza testified what I believe is credibly, and the minutes reflect that he worked for an outside company, and where he was working, there was a construction site across the street where they're working on a hotel, and there was a parking garage, and the employees of the construction company were directed to park in that garage, and Mr. Espinoza was also directed to park in that garage by the general contractor. Now, it's unusual because Mr. Espinoza is not in construction. He's not a subcontractor. But he was directed, and he was by the general contractor. And additionally, he was overseeing the movement of materials. And where the parking garage was, there were materials there. He needed to make sure that everybody worked in a safe manner, and if they did not, to report it back to the GC. So he didn't know whether to report the claim. I believe, based upon my conversations with him and also based upon my review of the record, when he reported the claim to his employer, I don't think they knew what to do with it. So he took it upon himself to get treatment. It doesn't seem like they have a lot of comp claims. They're unsophisticated in that regard. And his HR person testified that she didn't know anything about the site. So it went to trial. There was testimony of three parties, Mr. Espinoza, his supervisor and the HR representative. And the judge disallowed it based upon the fact that it did not arise out of in the course of employment because Mr. Espinoza was not under anybody's control. It's a novel situation, but I think we see it arise more and more frequently as companies start to use outside vendors.
Yeah, I think what was interesting there, like you mentioned the two witnesses from the employer that, weren't aware of this, this off-site location or technically on-site, depending on how you want to look at it, but controlled by the general contractor. Mr. Espinoza isn't working for the general contractor, and the Appellate Division seemed to credit the fact that his testimony was uncontroverted, that he was directed to use that garage, right? But, correct me if I'm wrong, Sarah, I don't think that his own employers would have the opportunity to direct him to use a garage that the general contractor was actually in control of, right?
Correct. There was nobody else from the employer there. The testimony really reflected the fact that there weren't work accidents frequently for this employer, if ever. I mean, maybe very minor things. But the testimony of the HR representative, Ms. Valente, she stated that she didn't have any information on the job site's procedures. She had never been there. She never worked at the accident location. She didn't have any information about the work performed there. Literally, she knew Mr. Espinoza was assigned to a site and made sure that he went to the site and that he was paid. There was an interesting part that I didn't put in the brief that I thought was, it was too complex or it could cause some confusion, but Mr. Espinoza had to sign in and out of work every day, and the sign-in book was in the garage. And he was actually the person responsible for reporting work accidents there because he was a safety person. And so he literally reported his own accident, and he reported it to HR. So it really was uncontroverted that this accident occurred. It was an unwitnessed accident, so either way, unwitnessed, it would have been compensable. It was really about the location and whether this arose out of and in the course of employment. Our sticking point from day one was the fact that he was directed to park there. The employees of the general contractor were parking there. And his job also crossed over with that particular site in that his sign-in sheet was there, his sign-in book was there, but also the materials were moving across the roadway to the hotel from that location.
Right. So
there were ties.
Yeah. So, I mean, it's interesting looking at the case and gleaning the facts just from the third department, appellate division. Like, we didn't litigate this one. This wasn't with our firm. I don't think we would have been discussing it if it was for various reasons. But so it's interesting piecing, looking at what the appellate division highlighted as far as the facts when we don't have the actual transcripts of the minutes to review and to see exactly what was elicited on testimony. But my takeaway is a couple of things. Number one, the board, the third department talks about the standard for upholding or not upholding board panel decisions, where really decisions won't be disturbed if they're supported by substantial evidence. And I think I speak for a lot of attorneys that are in comp that deal with a lot of board panel decisions in the appellate division. Nobody really knows what that standard means or how it would be applied, because it does look like in most cases when cases are before the board panel or even like this one before the third department, they're just looking at the facts themselves and deciding things almost de novo. They're not really giving any deference whatsoever, because looking at the facts, even as described in the appellate division decision, it does seem to me that the decision of the law judge and the board panel, there is evidence to support it, substantial evidence to support it. So I don't know how much the standard actually came into play or whether they care about it. That's number one. Now, number two, looking at it from the carrier side and how I would have litigated it, I do think that the default position, just the law, the case law, and for carrier attorneys is that, look, the coming and going, if you're going to and from work or the work site, the default is it's not going to be covered, and the claimant has to come up with a way to get around that or talk about how this is an exception or really, the circumstances are a little different. So even though this appeared on its face to be a pretty strong case for the carrier, and that was, brought out by the law judges in the board panel decision disallowing it. I think it's hard to get wins as a carrier attorney. We know that. A lot of things are tilted towards the claimants. It's very difficult to get wins. And when something is set up where you have a very strong case, you have to basically come hell or high water, fire and brimstone, everything you possibly can to shut the door on the claimant. Now, in this case, it strikes me as strange that the two witnesses that were brought were a director of human resources that is obviously, like you said, not going to know anything about the actual job site, the job of the claimant, or the details about where things are stored, where you have to go, signing anything like that. So there's basically no relevance to what she was going to testify to. And then the other employer witness is the vice president of the employer, who was basically just testifying that he wasn't aware of construction materials being stored across the street, that they were just a consultant, I guess, about site safety, and they didn't handle the building materials and wasn't responsible for the area across the street. So they didn't bring in anybody from the general contractor to testify in support of their position that, you know what, we don't care where this employer parks. He just has to be on site and do X, Y, and Z. Like, we don't really care. There wasn't anything brought out where the carrier is saying, hey, we have the general contractor who's going to tell us exactly what's going on here with the parking situation, how this guy gets to the job site, what he has to do, like, can he park anywhere else? So I really think if they spoke with the general contractor. They tried. So if they spoke with the general contractor and the general contractor, just didn't help them or provided, unfavorable information and they didn't bring him, fine, that's one thing. But, certainly that's something that would have had to have been brought out. They really needed to get a little more information here because it left the door open for the third department to just say, hey, the claimant testified this way, he was credible, and so carrier has nothing to the contrary, and we're just going to credit exactly what the claimant said. It's really funny because if the claimant was injured, say, in the middle of the street, he was hit by a car on his way to open the gate, it probably would not have been compensable.
Yeah,
he would have been in the public area and he was hit, incidental. He had left the job site. He left the initial job site and he signed out. So I think it's kind of interesting. I feel like if he was hit on the way to that gate before he started opening it to get to his car, probably would not have been deemed compensable. But once he got to the gate and started opening it, all of a sudden it's back to arising out of it in the course of.
Well, Sarah, you mentioned something like just while Noah was going over that. You said that they tried to contact the general contractor. Do you know that? I guess that
I do. The Travelers is a carrier in this case, and Travelers wanted to bring the GC in to testify. His testimony was ultimately precluded because he did not appear. And I think, as a former carrier attorney, I was looking at this as well. What do they do? Because the general contractor is not under their control. Would it have been a good practice point for a carrier to get a letter from the general contractor stating that? I think a letter would have held weight more so than having nothing. And that's, I think we may have been dead in the water if there was some kind of correspondence from the general contractor stating that my client was not directed to park anywhere.
Yeah, I'm curious here, Sarah.
Testimony.
I'm curious here because, I deal with a lot of almost primarily construction cases, and the policies that are implicated are called wrap-up policies, where the basically the developer or the owner of the project is the one that's getting all the insurance coverage for all of the parties, the contractors working on site, as opposed to most workers' compensation cases where it's done through the actual employer. Now, in this case, and I'll get to why this is so important in this case for gathering information. Do you know if the liable carrier was, if it was a wrap-up policy that was implicated, or if it was just the general policy for the employer?
I believe it was the general policy for the employer.
That would be my thinking also, considering that he wasn't an actual contractor doing any construction work. It was probably the general policy. And that makes it more difficult for them to get information out of the general contractor. Now, I think one of the biggest problems that we face, the carrier attorneys face in presenting witnesses or evidence, is actually getting the witnesses to testify, to be available to, because a lot of them don't have much incentive. Many of the witnesses for the actual companies, the construction companies, the contractors, don't want to testify against their fellow workers because it's not in their best interest. If they suffer an injury, they want the support of their fellow workers. They don't want to testify against fellow workers. Now, sometimes you have general contractors or the supervisors, And also, if it's covered under the operational policy and they're working, the general contractor here is covered under the wrap-up, a totally separate policy. So they're really not under the control of travelers at all. Now, when there's a wrap-up policy involved and they have their employer, but really they're all working for the developer or the owner's project, there we can put the screws to the general contractors or the employees of the contractors, because we're working with the developers, we're working with the owners, and the general contractors want that work. They're being used, and so there we have an advantage if it's under a wrap-up where we're more likely to be able to get those witnesses. In this case, it's like, hey, the general contractors have nothing to do with travelers. They really don't care. The employee was a supervisor, totally separate. So I can see why it would be a little more difficult. Now, it doesn't absolve, the carrier from, I don't know exactly what they did, what kind of efforts were made, but it certainly made it more difficult. And I think, like we're talking about here, it would have been extremely helpful if they had the general contractor testify, because that could have shut the door here. Now, I don't know what the general contractor would have testified to, but so generally, it is an issue. And if you have a wrap up, you have to be able to use the influence and the power of the developer and the owner to get all those employees for the subcontractors, the general contractors to testify. Would have been really helpful in this case.
And Sarah, I think one of the, like what Noah started off talking about, this like substantial evidence standard, right, where the board wouldn't be disturbed if the appellate division believed that there was substantial evidence to support the decision. Maybe asking it a different way, if the appellate division affirmed the board, would you be surprised?
That's a tough one, because, as you know, the standard at the board to appeal and to have a case established or disallowed is preponderance of the evidence, which is the substantial evidence when we get to the third department. So at the board level, is it more likely or not? And it's a much higher standard. I don't think the amount that things are affirmed in the court system, especially with the third department and the board, is extraordinary. We looked this up. Last year, there were 121 cases decided at the third department in 2022. I believe 11 or 14 of them were reversals. That was it. It wasn't many at all. And the number that were reversals from the law judge and the board panel agreeing and the third department reversing, I don't believe there were any, and I could be wrong. We had researched this. So I wouldn't have been surprised if we lost at all. And I think it's the nature of what we do. And I also think that workers' compensation in general, if you don't practice it every day, is very confusing. I give the third department a lot of credit for doing what they do, because these are not easy cases. And it's evident that there's a learning curve each time they have to look at these.
I totally agree with that. I think that, obviously the appellate division is not in the position to, generally disturb board decisions. I think that, you mentioned when you first started talking about this, like maybe is this a general special case? And now it makes me think, well, it's not like the decision was completely reversed and established there, right? It's remanded back to the board for further proceedings. And does that mean now the current carrier can use general special? Because the person who directed Mr. Espinoza to use this was not them, was not the employer, right? I think the third department is now relying on the fact that he had uncontroverted testimony that he was being directed to use this gate or use this parking area. But that's not the control of an operational policy of the current employer. Now Noah's like smirking at me, right? So what do you guys think here is if you guys, Sarah, you're a former carrier's attorney, Noah, you're currently doing this every day. What do you think that would have a shot when you go back for the remand?
I think that there's one little caveat here. He's the only employee there from his employer, and he's in a supervisory role. So if he's making the decision to do this, and he is, I don't know even if there was that relationship found, whether travelers in this case would receive any relief, because he's there, they trust him to be there, they trust him to, follow what directions are best. And also, the other catch is here, the building materials were where he parked, and he was responsible for watching the building materials. So it's, I don't know, and the third department wasn't super clear in the decision as far as I can read. Maybe you'll have a different take on this, especially Noah with the direction. It seems to me that because the building materials were there, that was like the final nail in the coffin, right? It's not just that he was directed to park there. It's that he had to be over in that building anyway for work, which is arising out of in the course of an employment. He has to be there anyway.
Yeah, I mean,
So
it's an important fact. It's one of the facts that goes into it. But again, I would want to know more detail as far as why it's stored there day to day during the actual job during the day. Is he ever there? Like, does it matter? If he looks at the materials when they're over there, or is he just responsible when they come to the job site? The materials and the equipment. So again, I would want more facts. I would have wanted to elicit a little more testimony. Again, the general contractor would have been key. I have a couple other questions. Now, after it was disallowed and the board panel affirmed, before you got this favorable decision, did the carrier reach out to you at all about settling it and having you withdraw the third department appeal?
No, in fact, the carrier attorney is my former boss, and I got a call and he said, "Kiddo, I can't believe you're appealing this."
Wow. Now, I got to tell you, look, from a very aggressive carrier attorney, if I secured a disallowance and the board panel affirmed and the full board denied review, and the only thing that was pending was the Appellate Division, I would be reluctant to offer anything. But looking at how the facts were brought out in this case, including the carriers being unable to get the general contractor to testify, I would have been worried at least a little bit. Now, I know you said the statistics were basically like, 199% that the third department would just not change anything, but I would have been a little worried. And I'm just curious if there was a settlement offer made, not a joke settlement offer, but if they had actually offered something like $5,000, $10,000, if, you would have actually considered it and withdrawn the third department appeal.
I don't know, and that's a good question. I think that sometimes, we look at this in such a case-by-case basis. And like I said, I wouldn't have been surprised if the third department just affirmed the board panel and the judge. But at the same time, I looked at this as well. This is silly. I mean, there's case law, and obviously we cited substantially more case law in our brief than what the third department relied upon, because they relied upon Husted, which is practitioners we see all the time. But I just, I really thought there's a chance at winning this one. And I don't know if we would have said to the client, well, if you take, and I don't have a good answer. We didn't get a sincere settlement offer. I don't think we got any to the best of my knowledge. I could be wrong because I didn't handle this until the appellate level. But even if I got an offer for $5,000, I think I presented to my client and said, well, you're going to have to wait a long time. And that's the issue, right? And when I called him after we won, he said, well, I don't even have a case. What are you talking about?
Man, so they would have been able to get that settlement for nothing. He thinks it's done.
Yeah.
But no, I think it's just good practice Look, obviously it's more relevant if, there's a pending appeal before the board panel. It's very rare you get a case like this before the third department. But I think it's just good practice for carrier attorneys to see if there's something there, settling it for nuisance or minimal value, when the exposure would be much more significant if it was reversed. Now, in this case, just along those lines, at the, substantively, was there like a concession in the medical record as far as the, the biceps tear, the rotator cuff tear, that it was all related to this accident?
Well, the catch is here, too, and this is one of the reasons I'm surprised it wasn't affirmed. My client went and got surgery immediately. I mean, it didn't go through, our prior system with the MG2s. It didn't go through the equivalent of the PAR system. He went and just had surgery. So he was fixed, by the time anybody could examine him, the problem was solved. So, and I mean, yes, an IME could examine him and comment, well, I think this is related. But if you don't see somebody at their worst and you see them after they're repaired, I don't know how accurate that can be. I'm not a doctor, but I think it puts them at a disadvantage. And again, it was surprising based upon those facts that was one of the things that surprised me, that we were able to win at the third department, because obviously the board and the board panel frown upon people getting treatment that's not authorized.
Yeah, so I guess my question is more specifically, like, what is the actual posture of the claim right now? Is it established?
It's my impression that it's going to be established. I mean, the decision is remitted to the workers' comp board for proceedings not inconsistent with the decision, which means that the accident arose out of and in the course of employment.
Right, but then it would leave open the causal relationship aspect, potentially.
Correct.
Now, I know there's difficulties. You
Yeah.
mentioned there's a lot of difficulties in litigating that, considering that he apparently had the surgery to repair the tear after. But it does look like if the carrier wanted to, they could decide to, hey, we want to get an IME, we want to cross-examine his doctor and go on the causal relationship. Now, I don't want to get into it.
Unless they waived it, right? They could have.
I know. I don't know exactly what happened as far as...
The IME, I think, was precluded at one point, and again, it's been a while, and I can look in the record, but I believe there was discussion of an IME, and again, from the carrier's point of view, this could have very well been a slam dunk for them, right? I mean, I think we were very surprised when we got the decision. So is it worth the time to risk the IME? Is it worth the cost?
Well, I mean, in this case, it looks like, again, I don't want to get into so many specifics because it's ongoing. You know, I don't know how much you would want to actually divulge or disclose, but it looks like, just from the facts that the third department laid out here, that he suffered a pretty discrete injury, a specific injury, tearing the rotator cuff tear. I don't know if he suffered a biceps tear. It says an injury to the biceps. And then he had a surgery that may have been successful. I mean, he had it only a few days after, so you think it was addressing a very specific problem. And so you'd be looking at, pretty specific schedule, loss of use. They would know exactly what kind of exposure they had, and especially if the surgery was successful, not much in the way of medical. But again, it's been a long time. So I don't know. I don't know what the carrier would want to do. I think part of me as a carrier attorney would be so annoyed at this decision for reversing, but then I would be like, hey, the only thing they actually addressed was arising out of it in the course and scope of employment, so we still have that causal relationship prong to do. And yeah, sure, let's spend a few $1,000s on an IME and depositions and try to not give the claimant anything yet.
Yeah, we're not pitching for the file, but if there was a pitch, that sounded like a great pitch to me, Noah. I guess, Sarah, to then go to the end of the decision, right? And you would know this better than us, right? I always love these sentences at the end where it says, to the extent that the parties' remaining contentions are properly before us, they have been considered and found to be without merit or are academic in light of our decision. So, in layman's terms, hey, like, you won, go celebrate, good job. We're not going to address your other arguments because that's not relevant in the case, or to the extent that you've now won the decision. Any color that you can put into those arguments? Was there anything there that maybe you wanted to talk about?
Well, if you look at the beginning of the decision, there were two issues on appeal. And one was that there was an issue with whether our clients' due process rights were violated upon the full board denying review. And the basis of that was the fact that these same three commissioners who determined the board panel, who decided at the board panel that our clients did not have a viable case, also denied full board review. This was the second time we brought this up to the Appellate Division, and the second time that the issue, that the Appellate Division decided not to address it. And obviously, it was decided on the merits, and they didn't feel the need to address it. The board's volume is enormous. This year, again, because I looked it up, as a few weeks ago, there were 7,800 decisions, I believe, from the board panel.
Over 20 a day. And that's using it 365 days, so that's crazy.
Right.
But they're all generated by your office.
Oh, okay.
No, we have an outsized proportion of it, but thank you. We're flattered.
No, but in general, I am teasing, but no, in general, I mean, it's what I've seen is that it's some of the appeals. You and I both know. We all know this. Is there, for administrative correction, because there's no other remedy, right? So let's say 10% of our administrative correction. That's still an enormous amount of decisions the board's putting out. I don't know. I believe they must be cognizant of the issue. We do have another brief pending that has been perfected on the issue, and it's available to the public, through the NISIF system, which is the electronic filing system for the court system, and it's certainly publicly available. And the issue's up on appeal, and this time it's the only issue up on appeal. There aren't any other issues, so it'll be interesting to see what action is taken. I don't know. I've vetted past a few people who I think are phenomenal appellate attorneys and phenomenal litigators, and nobody knows how it's going to be decided. Is it simply administrative in nature, or is it something else? I don't know, but I would like it to be addressed. When I first started practicing, I believe there was only one commissioner signing off on the full board denial, and that changed, a number of years ago. So I don't know. With the volume we have, I don't know if there's a good explanation or good resolution. But this is the third time we've brought it up on appeal with the appeal pending right now.
I think, honestly,
it'll be interesting.
I think that's a really interesting issue. Just for basic background for anybody listening, obviously you bring an appeal before the board panel. There's 3 members of the board that render a decision or sign off on a decision. And then when you bring it to the next level and ask for discretionary full board review, there's another 3 that sign off, correct?
Yeah.
Yeah, so in this
exactly.
case, the same three members signed off on the board panel decision affirming the law judge's decision. And then the same 3, right, they were the same 3 that signed off on the full board application saying, we didn't make any mistakes of fact or law. Our decision is fine, therefore you're done. It does rub you. It seems like, hey, more than the appearance of impropriety, it just doesn't make a lot of sense if you're going to allow that avenue for review to just have the same exact people dealing with it. And I'm also very interested in
especially
what
because
the third department's going to say.
Rejecting a discretionary appeal can just be, it's just a rubber stamp.
Yes.
Right? It wouldn't be that hard to have 3 other members rubber stamp a unanimous board panel decision. But that is very interesting. And Sarah, I like disrupting, so I'm very anxious for that one to come out. And
actually related to that, I'm wondering, look, I'm not saying it had any impact, but sometimes when you file an appeal, even just to the board panel, which is what we generally are doing, sometimes to the third department, you put in a lot. Sometimes there's several arguments that you're making here. In this case, you had 2. And sometimes the board panel, and in this case, maybe the third party, they don't want to deal with some of the issues. They kind of want to just kick the can down the road, or they don't want to open that can of worms. In this case, is it possible that the third department sees, hey, you know what? There's 2 arguments here. Maybe the first one's viable, that it arose out of in the course of in scope of employment. And you know what? If we find that way, we don't have to deal with this really thorny issue of whether the workers' compensation board is acting appropriately, or where we're actually going to have to tell the workers' compensation board, hey, by the way, you need to change your practices. So maybe, hey, you know what? I don't want to deal with that. So let's just find that it's I'm not saying that actually had an impact, but the fact that they found this way, they didn't have to deal with that. Though you're saying that it's something they have to now.
If they affirm the disallowance, they would have to address the second issue.
Yeah.
Right. Yeah. But which makes your point clear, Sarah. Is like you're going to the third department on just that issue, and so it kind of has to be addressed.
Yeah, and that was a decision made not just by me. I can't take the credit for that. That was by people much smarter than I am. Certainly, people I respect greatly. But it's the first time this came up, the AG's office didn't respond, and it was a very difficult brief. It was actually against another claimant's attorney. And again, these are all publicly available decisions. They're all publicly available. The briefs are, the records are. And so it was a discussion, about, well, we're going to bring it up. Are they going to address it? And we lost at the third department. So I think what's interesting is the fact that we did win this time and they didn't address it. I'm not going to say I'm going to keep on fighting until I get an answer. We may not get an answer, and it's the nature of what we do. The other question is, it's an administrative law, so what rules apply and what don't. And I think I made a viable argument about what rules I believe apply, but that doesn't mean anybody has to agree with me. I mean, that's why we practice law and we have multiple attorneys in a case. So,
Yeah, I mean, I
I
think it's more of an interesting like academic question, because ultimately, even if you prevail, what's the third department? What are they going to say? They just be like, okay, when you have a full board review, make sure that you switch up the members. But it's not going to be like some kind of crazy substantive change. So, like, let's say you're successful in your pending third department on that issue. They'll be like, all right, so we're going to send it to 3 different commissioners to deny your full board a review application, something like that. But I'm just interested in what they say about the board's practices and what if they're doing it properly.
Well, there's also something we're all missing as practitioners that came to my attention with the most recent appeal that I perfected. And I don't think that I ever realized this, and I don't know how I missed it. Yes, if there's an abuse of discretion or it's arbitrary and capricious, it can be, those are 2 of the standards for discretionary full board review to be granted. But did you know that if the board panel fails to address one of the issues or one of the points in the board panel decision, there's case law on it that actually full board review should be granted? Because I think we see a lot of times that we make arguments that are brushed aside or not addressed at all in the board panel decision. And in fact, the case law actually states that that there is another reason that the full board can grant review, which is that the board panel failed to address all the issues before it. Again, with the volume, I don't know if
it's interesting you say that, because I am waiting now over 2 years on a full board decision because the board panel decided to not address one of the issues. Has to do with the 15.3W credit that everybody is still confused on. Maybe they don't have the direction or they don't know what to do. It's been over 2 years now, and we're still waiting on it because the board panel, when they
kicked the can
considered
down.
the appeal, straight up ignored that issue, didn't address it at all. And so sometimes you do get amended board panel decisions like, oh yeah, by the way, this. But this doesn't seem like it's that instance. Like, hey, you don't address something, please address it, so that we can move on with our lives. But yeah, that's something to think about.
Well, in practice, though, the other thing that I've seen is that I've had it happen twice where there's been an amended decision, so the third department didn't take action. I've had it happen twice, and it was a number of years ago both times. And the AG's office was gracious enough to call me and say, hey, we made a mistake, or hey, this issue is resolved. And those were the 2. One was simply that somebody forgot the word not in case law, and it changed the whole meaning of everything. And that was about 11 years ago or so. And then the second one was the issue was basically resolved among the parties, and so they issued an amended decision. In this case, I mean, one of the things I also thought about was I've written a lot of appeals, and I've had one board panel dissent once, and it actually was and then it went to a full board where the full board dissented. But the dissenting opinions aren't common, and I don't know if it's just an overloaded system, or not a broken system per se. I mean, obviously we're all here and we're getting stuff done, and our clients are being taken care of. But I don't know what the resolution is. And again, I think that's for people much smarter than I am to determine. But it's certainly 7,800 appeals or 7,300, whatever it was by October, speaks to the volume of what we're all doing. I mean, the number of hearings we have a week, we're all very blessed, and we're blessed to have jobs, and it's extraordinary. But at what point does the process have to change so that it's a little bit more efficient and maybe more cognizant of the issues before it? I mean, and we'll be honest, sometimes there's some places and some people or firms that appeal everything. And so then, is that also bogging down the system? I don't know if there's a good answer, but I'd like to find out.
Yeah, I mean, I think the board's taking some steps to it, right? I mean, you spoke about the shoulder surgery going outside of the PAR process, right? And I actually believe the PAR process, whether we want to say that's good or bad, it does take away potential appeals when decisions have to be made on treatment within 4 calendar days at each level. I have to also imagine that, the 3 of us know that there are particular law judges that don't like getting appealed, right? So they have to be cognizant of creating a good record, creating that substantial evidence that if they have to get appealed, then maybe they want to win out and, it's important to them, just like it would be to any of us, I feel like, if we were on the bench. But I think that's probably a topic for another day. I think this is probably a good time to close and celebrate, Sarah, your trot around the bases for your firm. A good win for you guys on the claimant side. Not a great result for us, but I think it's the analysis of this decision, like what happened before, the color you could provide, and really know like a lot of the things that you would have done or really would do even into the future with this case was really interesting to me. So I want to thank you both for coming on to the show, and this will be our obviously our November edition of the podcast. So for Noah Pollack and for Sarah Baia, this is Christian Sison reminding you to defend from day one.